Hi, welcome back to my 5-part video series on conducting effective witness interviews that can maximize your case results and your firm's revenue while helping to keep costs down so your client can keep more of the settlement amount you earned for her. In today's video, we'll discuss planning out the interview process to increase the success of the witness interview. We'll cover methods and manner of contact, who will conduct the interview, what needs to be covered, and by this I mean categories versus specific questions, and finally, notes versus recording the interview. In the first video, we discussed the mindset hacks that will take your witness interviews from mediocre to effective. In subsequent videos, we'll discuss the importance of making contact with the witness to start building rapport, the importance of a good first impression, the power of rapport in creating effective witness interviews, and helping the witness to feel more comfortable being interviewed. Then we'll cover the most common objections witnesses have to being interviewed and approaches you can take to discuss those objections with the witness and get him to move ahead with the interview, and how to keep the door open to an eventual interview when you hit an objection that's too challenging to move forward at that specific time. And finally, we'll talk about how to approach the Q&A portion of the interview to get the information you really need, how to document the interview, and how to obtain a statement or declaration that can be used to combat summary judgment motions. Hi, I'm Mike Corwin. I teach civil plaintiff law firms how to conduct effective litigation investigations that maximize their case results. I spent 30 plus years building cases for civil plaintiff attorneys in Los Angeles, California, and Albuquerque, New Mexico. During that time, I conducted over 12,000 witness interviews. I've taught hundreds of attorneys, paralegals, legal assistants, and law school students how to conduct more effective litigation investigations. And if you're ready to take your firm's witness interviews to the next level, I've got something special for you. It's my free PDF, 6 steps to more effective witness interviews that maximize your case outcomes. Just click on the link in the description below to download it now and get started today. And if you missed the first video in this series, you can find a link to it in the description below as well. Now, let's dig in. When it comes to planning for your witness interview, there's a few things that we want to talk about. I'm pretty sure anybody who's ever worked for an attorney has at some point in their life experienced a situation where they showed up at work, on their desk or through an email is a message that simply says, call so-and-so at this number, this person has information. That's virtually impossible to be able to do a proper witness interview if you don't do some initial planning. And here's why. When we contact a witness, we're looking to find out specific information. Can we corroborate something? Maybe we need to disprove something. Maybe they're just a straight fact witness and we want to know exactly what they saw from where and when and at what time. Now, when it comes to planning, the information that you're usually working from is either going to be information provided to you by a client, it might be information from another witness interview or a deposition, it may be from a police report or other incident type form. What are you trying to get from this witness? Are you trying to prove something, disprove something? Are you trying to get credibility information on a defendant? Are you just a straight fact witness and you just need to know what they say? But what I like to do is for each witness that we're going to interview, I like to have kind of some categories of what I want to cover. Now notice I didn't say specific questions. Yes, maybe a question or two, but more importantly, we're after categories of information because ultimately we want them to talk more. And when we're spending our time working from a prepared list of questions, they're going to talk less. The other thing is I believe that when you work from topics, you're able to free flow a little better for the interview. And I think the better that you free flow, the more likely you are to get better information. There's a couple of things that we also need to consider. One, who from the staff is going to conduct this witness interview? Is it going to be an attorney with a legal assistant together? Is it just going to be the legal assistant? Is it just going to be the attorney? You have to figure out that process and determine who is best suited for this interview and whether it's something that you want to actually have a little bit of a staff witness for. The other thing is, on occasion, it may make sense to use an outside investigator to do your interviews. And I think that's best for either someone who has the likelihood may change their story, or it's somebody that you think maybe there's some safety concerns for your staff that you don't want to have to deal with on that. And so in those cases, I think that it makes sense for you to have an independent person conduct the interviews. But for the vast majority of work you do, I believe your own staff or an attorney with staff can do those types of interviews. Along the lines of how to contact and which ways to do it, you essentially have 3 ways, and I'm going to give them to you from the most effective to the least effective. So the most effective approach is what I call an in-person cold call. That means you basically just show up, whether it's at their home or at their place of business, and you introduce yourself and you try to get them to agree to be interviewed. Now, one of the benefits of that is, one, it's a surprise, and most people aren't expecting it, so their defenses are not elevated at that point in time. The next thing is that it's also really beneficial because we are, as a society, a culture to believe that a guest or a visitor needs to be treated like a guest. So we tend to be more responsive to them. We tend to want to please them a little bit more, and this is just our programming, so that we're less likely to get a no when we show up. And also, the witness, when you show up, they get to see who you are and what you look like, and that also gives them a little bit of a decent feeling. The second most effective way is to call them on the phone and just try to cold call them right there. Now, again, doing a phone interview, it's a little bit of a challenge because you're going to have a few things you have to get through. You have to get through caller ID. You might need to get through voicemail. You might need to get through a family member or somebody else who can answer the phone. You have to make a decision. Am I going to try to interview this person just by me calling them? Or do I leave a number and ask for them to call back? Obviously, if you leave a number and ask for them to call back, you have to give them a reason for calling back. So you really have to say who you are and why you're calling. If you do catch that person right off the bat, their guard is down, they're going to be more frank, they're going to provide more information, so that is a really good way to do the contact. The third way, and sometimes it can be more effective, but generally speaking it's a little less effective, is to call and make an appointment with the person. Now, that works best on something like an auto accident case because there's not as much about sides or about paychecks or any of the other things that plaintiff lawyers can be bringing cases on. This is literally just about somebody who saw something and happened to be at that location. So those are a little easier to schedule. Now, the one major downside to calling and scheduling is the witness can no-show. And so generally speaking, you want to make that happen within about 48 hours of that. And if it can't be scheduled within 48 hours of your call, then you need to do a follow-up, either an email or a telephone call, and just do a reminder. Hey, just want to remind you that we're going to be meeting on such time at such and such location. Should you take notes, either type them, do handwritten notes, or should you record the interview? Now, this question usually produces very strong opinions. People that come from law enforcement backgrounds, former district attorneys, they like to record everything. However, coming up from the defense side and the civil rights side, I always preferred to take notes rather than record. And here's why. I believe, one, that recording, the person you're recording is going to really be focused on the device, right? That thing that's recording them, that can take away from the interview. And if you think about it, how free-flowing is someone going to be when they're looking at your device? They're not going to be really free-flowing. Yes, there are some people who are comfortable with it, but the vast majority of people are going to be very stilted in the interview. The next thing that I like with taking notes is you can use the column side if you're writing, or you can just space up and type in anything that you come to later in the interview that actually is connected to something that you dealt with earlier. And it's also a great excuse for getting a person to slow down and to actually confirm something with them. And what I like to say is, hey, let me back you up for a second while I'm taking the notes. What you said before was X. Is that correct? And then they'll go back in, and chances are pretty good they will fill in the blanks on that. The other thing is, and it depends on the court you're in and in terms of reciprocal discovery, but if you think about it, when you interview a witness with a tape recorder, you're one, asking them to identify themselves. Two, you're asking them to affirm that they agree to this interview. And then at the end, you have to do it again. And basically, you are giving them a verbatim and affirmed interview. And I think that your defense counsel will have a better chance, if they can't find the witness, to interview, to get your work. And you may not want them to get your work. So if you are taking notes and then you turn that into a summary, it becomes your impression of what the witness is saying rather than a verbatim transcript. So I think from a discovery perspective too, that gives you a benefit. And if you're ready to take your firm's witness interviews to the next level, I've got something special for you. It's my free PDF, 6 Steps to More Effective Witness Interviews that maximize your case outcomes. Just click on the link in the description below to download it and get started today. And if you missed the first video in this series, you can find a link to it in the description below.